Chief Justice, Justices of the Constitutional Court, Ms. Lewis and I appear for the applicant, Modikwa Platinum Mine.
Thank you, Mr. Brindis.
Chief Justice Maya and Justices of the Constitutional Court, my learned friend Mrs. Fourie and I appear on behalf of the first respondent, Nkwe.
Thank you, Mr. Roux. You may start, Mr. Brindis.
Thank you, Chief Justice. So this morning, the Constitutional Court is hearing what I colloquially refer to as a spoliation appeal, an appeal from the Supreme Court of Appeal, which dismissed an appeal against a decision of the Polokwane High Court. And what the SCA found, or it dismissed the appeal essentially because it found that Modikwa Platinum Mine, MPM, relied on hearsay material in the spoliation application. Now, we say that when the SCA made that finding, it got it wrong because the hearsay material to which it refers was material relied on by MPM in the application for the purpose of urgency. So they relied on that material to show when it is that they became aware of Nkwe's occupation of Mandagshoek. What MPM did not do was it did not rely on that material for the spoliation application proper. In other words, it didn't rely on that material for the purpose of proving possession or occupation without a court order, statutory enactment, or its consent. In fact, as you will know from the papers, it's not disputed that MPM occupied Mandagshoek since 2002, since when they've been mining platinum on Mandagshoek. It's not disputed that they occupy their mining area constituted by Mandagshoek. And nor is it disputed that during January 2021, Nkwe occupied Mandagshoek for the purpose of carrying out activities there which are related to its mining on a related property, which is adjacent, that's Garato, over which it holds a mining right. And it's not disputed that Nkwe does not hold a mining right over Mandagshoek. Now, if that's the case, then really the only question is, does Nkwe have a defense to the spoliation application? That's really the only question. And it is a question which the SCA should have decided, but did not, because it wrongly assumed that hearsay material, newspaper articles, were relied on for the purpose of the spoliation application proper.
So you did say you waive your uninterrupted
time. Oh,
time.
yes.
Okay. I just wanted to ask you what questions, in your view, were before the SCA?
So the questions before the SCA were whether Nkwe, whether it was a defense to the spoliation application that Nkwe was the holder of statutory authorizations, being principally an EA, an environmental authorization, and a water use license. That was essentially the question before the SCA. And as we say, the SCA didn't decide that question. It dismissed the appeal on the basis of assuming that what was relied on for the spoliation application was newspaper articles, and of course that's clearly not the case. So what we say that the SCA got that wrong, and we say that then leaves the Constitutional Court to decide the question, which is are statutory authorizations such as the ones in question, the environmental authorization and the water use license, are they defenses to a spoliation application? We say no, and we say they are not, because the only defenses to a spoliation application are statutory enactment, court order, consent of the occupier, and for the purposes of remedy, impossibility. So those are the only defenses that you could raise. Those statutory authorizations are not statutory enactments. In other words, they are not statutory enactments that authorize occupation of Maandagshoek against the consent of an occupier. In fact, we know that Nkwe never thought that was the case because it sought the consent of everybody, all occupiers, bar MPM, bar the holder of the mining right who was occupying the Maandagshoek for the purpose of mining there. So it's not as if they thought that they didn't need consent. They clearly understood they did need it, but whether they did or didn't doesn't matter. You need the consent of the occupier in order to occupy a property, and if you do so against the consent of the occupier, there are numerous authorities to which we have referred in our heads of argument, which say that that's spoliation. Well, it amounts to self-help, spoliation, and the court can order you to vacate and restore.
Mr. Breinders, just a follow-up to that question. So you say all the questions that the SCA was supposed to consider, are those set out in your founding affidavit, paragraph 10?
Correct.
Yes. Now, coming to 10.3, the question where it says, did the actions taken by the first respondent amount to compliance with section 5, capital AC of the MPRDA? It's at page 660 of my record. I know maybe we have different numbers. My interest is on section 5, capital AC.
Yes.
The one that says one must, giving the landowner or lawful occupier of the land in question at least 21 days written notice. I want to know if it says landowner or occupier, and according to Nkwe, they said the landowner had consented. Are you covered by that provision?
So
because it doesn't say and, it says or.
So the first point in response to your question is the 5A interdict was the alternative. In other words, the application was first spoliation, and if the spoliation didn't succeed, then in the alternative, in other words, if the court found respectfully, correctly that it wasn't a spoliation, their occupation, then we rely on then the 5A interdict was in play. So first we have to decide whether there was a spoliation here. If the Constitutional Court decides that there wasn't a spoliation, well then the interdict comes into play. As for the interdict, we say or there is conjunctive, not disjunctive. It can't be disjunctive. The whole scheme of the Act, the MPRDA, is that occupiers must give consent. In other words, you can't. I mean, the scheme of the Act is not that holders of mining rights can simply, without the consent, walk onto their mining area and start mining. That's the first. And second is you can under the Act, but then you're going to have to give notice. And the reason for that is because the Act has a scheme for disputes over between occupiers and mining rights holders. It has a scheme for disputes where ultimately you can determine by arbitration how to deal with essentially money. In other words, what are you going to pay me for interfering with my occupation of the property?
Okay. Now let's go back. Let's start now with spoliation. Then we move to the interdict later. Modikwa discovered that Nkwe had occupied the area. And initially a letter was written to Nkwe. Nkwe did not move out. And then Modikwa approached the High Court for spoliation. Ordinarily, under spoliation, if you are in peaceful possession, the High Court should have, according to applicant, should have ordered Nkwe to vacate, and then the issue of lawfulness should have been dealt with as a second leg of the inquiry. That's your argument?
Correct.
Now, there's an argument by Nkwe that says Modikwa should not have run to court. It did not exhaust internal remedies. Do you have any response to that argument?
Well, there's no requirement that you must exhaust internal remedies before you bring a spoliation application. I mean, that applies in administrative law, but it doesn't apply to spoliation. We're talking here about self-help, and the law doesn't tolerate self-help. I mean, the Constitutional Court has said that on more than one occasion. You don't have to, where a party does not, well, firstly, a party can't, it can't put up the defense that you must exhaust internal administrative remedies under the Act when it resorts to self-help without itself having utilized those internal remedies or gone to court to get itself onto the land. So that's, yes, we say that that's a bad defense, it's a bad argument, because, well, firstly, it doesn't apply to spoliation, and you can see how it can't lie in the mouth of the person who doesn't comply with the law or the Act to say, well, you must first comply with the law before you seek to vindicate your rights. That's what we're doing. Sorry.
Mr. Brandis? Can I start where we ought to have started, or you ought to have started? Whether this court has jurisdiction to entertain this matter. I do so because when you kicked off, you submitted that the SCA did not decide the issues. The SCA relied on media statements which were advanced by your client to demonstrate the urgency of the matter. So that seems to be the fundament of the SCA's judgment. If we put that judgment aside, then we would have the judgment of the High Court. Now, on the basis of the judgment of the High Court, assuming we accept that the SCA did not decide the issues, on the judgment of the High Court itself, do we, or does this court find jurisdiction to entertain this matter? And if so, on what basis? Spoliation is a tried and tested legal principle that has applied over many years. And you would be well aware that if there is a misapplication of the law, in other words, if the High Court misapplied the test required for spoliation, that would not engage this court's jurisdiction, unless if it is an error of law, which this court in Villacrop said that engages our jurisdiction. Those are the two nuances that I need to ask you about. And one, what is your submission on the misapplication of the law by the High Court? Two, if it constitutes an error of law, what is that error of law that engages our jurisdiction?
So to start at the end, the error of law is that it found that a statutory authorization is a defense to spoliation. That's an error of law. That's not a defense to a spoliation application, as we pointed out earlier. So that's the narrow basis of our answer. The broader basis of our answer is that this court's jurisdiction is engaged in a spoliation application because It's a rule of law matter. What happened, spoliation applications are quintessentially about complaints that a litigant has resorted to self-help when occupying a property. Quintessentially, that's the case. And this court has said is it Kukumba, yeah. That one in Schubert, it said that in spoliation applications, this court's jurisdiction is engaged because of the rule of law issue, because it raises a rule of law issue.
Okay, having cleared the desk. Now, the issues which the Chief Justice put before you at the beginning, that was a spoliation and also the statutory authorizations. The High Court found that the statutory authorizations permit or allowed Nkwe to occupy the property. In other words, it has met the defense of spoliation. And you would say that is wrong.
Excuse me, Justice.
And you'd say the finding of the High Court that the statutory authorization permitted Nkwe to occupy Manda's Hook is wrong.
Without the consent of MPM,
Yes.
is wrong. Yes, because that was the issue before, is it Judge Makhoba, I think it was, in the High Court. The issue before Judge Makhoba was MPM said, well, they've occupied without a court order or our consent. And Nkwe said, but we've got an EA. They accepted they didn't have our consent. In fact, in the papers in the High Court, they don't raise tacit consent as they do now. They don't raise it at all in the High Court. Their primary defense in the High Court was that they had this statutory authorization and that permitted them to occupy without MPM's consent. We say, well, that's not, it isn't a defense to a spoliation application to say I've got a statutory authorization, therefore I don't need your consent or a court order or a statutory enactment, but that never arose in this case. Nobody ever thought that there was a statutory enactment that permitted or authorized occupation without MPM's consent. So the question was, is there a court order or do they have our consent?
Does the fallback position adopted by Nkwe about the various consents that it obtained inter alia from the landowner, excluding the land occupier, which is your client, the maize farmers, the ostensible consent by the 4 directors purporting to act on behalf of Modikwa, have anything to do with validating their stance that there indeed was consent?
No, I don't think that they don't allege that they had consent from MPM, from Modikwa Platinum Mine.
By the 4 directors?
No, that's not consent of Modikwa Platinum Mine.
I'm sorry, I didn't catch the last bit of your...
It's not consent from Modikwa Platinum Mine. Those 4 directors, they don't say that they got consent in the context of approaching the mine to get consent. That's in the context of people who are occupiers there. And you know that they need our consent because if you look at that, let me just take you there. If you look at that EA, sorry, Justice, I just want to find this. So if you look at the the bottom of the EA, it says this EA, so I can't find it now, but this EA doesn't excuse it doesn't mean that you don't have responsibility for complying with statutory provisions. That's what it says. So let me just, I'll find it in my notes. Just bear with me one moment. Yes, so what it says is, it's volume 5, sorry, at 441. The EA expressly provides that the EA does not negate compliance with any other statutory requirements. That's what the EA specifically says. Now, a statutory requirement that would apply, that does apply here, is Section 41 of the Mining Titles Registration Act, 16 of 1967. And under that act, so it regulates, obviously, the registration of mining titles. But it also provides for the registration of leases, long leases. And you will know in this case that a long lease was concluded. In fact, that is the evidence which is being introduced on appeal, that a long lease was concluded last year, I think in September, and it's not yet registered. Now, the Mining Titles Registration Act...
But sorry to interrupt you. The long lease and everything else is ex post facto your case, because as I understand the papers, as I understand your case, what ought to have been determined is simply, one, whether you were in peaceful and undisturbed occupation of the area. Two, whether Nkwe despoiled you. And if on the common cause facts, Nkwe despoiled you, then you ought, or you must be entitled to your order of restoration.
Yes.
And as far as the defenses about the rights, the entitlements, they go according to the merits, not on the fact that you are in possession and somebody has disturbed your possession. Would that be the basis?
Yes, Justice, so that's correct. So leave aside for the moment the question that the EA itself, so if you look at the EA at volume 5, page, where is it? I had it a moment ago. If you look at it, volume 5, 440, so if you look at the EA, it doesn't authorize occupation against the consent of an occupier such as the mining rights holder. I mean, in its own terms, it doesn't do that. What Nkwe at the High Court contended was that the EA authorized them to occupy without our consent. Of course, they got the consent of other occupiers and government landowner and so on, but they didn't get our consent. And the question before Judge Makgoba was, is that a defense to a spoliation application? We say, well, it's not, because it's not a court order, it's not a statutory enactment, and they never got our consent. So it can't be a defense to a spoliation application. And remember, they don't dispute that we are in free and undisturbed possession, and they don't dispute that they occupy.
Let me finish. If we are with you, there is no need, correct me if I'm wrong, to engage into the exercise about the interlocutory application and stuff like that. Because that would be introducing a different landscape post the initial spoliation. But however, if we are not with you, that would necessarily entail that we consider the position after. Would that be an attractive proposition to embrace or not?
Well, if you're not with MPM on the spoliation, in other words, if you find that it didn't constitute spoliation, then that isn't the end of the matter, because there's the alternative of the interdict. And that was never considered by Judge Makgoba or the SCA. And we say, considering our interdict, we didn't get the 21 days notice. They're not entitled to. It's a breach of the statute, and we were entitled to our interdict at the time, and we still are. So then there's the alternative. But on the spoliation, I mean, if we didn't spoliate, then, well, there's no remedy. The application is dismissed. I mean, what happens afterwards doesn't really come into it.
Okay, thank you.
On the question of the alternative relief, Modikwa sought the interdict. What should we make of the submission? Well, the question will be put to Mr. Roux when his turn comes, but I want to ask you, what should we make of Nkwe's submission that Modikwa did not exhaust the internal remedies available to it?
No, but there's no, so that's a simple statutory requirement, that you must give 21 days written notice before you occupy. There's no internal remedy that applies here. We're entitled to, that's a statutory requirement. It's not an administrative act. We're entitled, where there's a breach of the statutory provision, we're entitled to relief following upon the breach. And that's Pats versus Green, and all. We gave those authorities in our heads, which say that we're entitled to an interdict where there's a breach of a statutory requirement.
Do you, however, dispute that there were internal remedies available to Modikwa?
No, they're not. There are no alternative remedies to 5A. No. You've got to give notice, and if you don't, we're entitled to come to court to vindicate our right. Because remember, we have a statutory right there, so we're entitled to vindicate that right. But can I come back to the spoliation, because that's the key. Well, that's the main application. The alternative is the 5A interdict. As for the spoliation, we do say that, as Justice Matopo put it, it is as simple as free and undisturbed possession by MPM, and then occupation without MPM's consent by Nkwe. It is as simple as that. And if that's the case, then you've got spoliation. The only question that arises is, well, is that EA a defense to the spoliation application? We say it's not. We've made our submissions in that regard. So we submit respectfully that the court is bound to find on the facts that there's free and undisturbed possession and that there was an occupation without our consent. The court must find that. And then the next question that arises is the environmental authority or water use license, are those defenses to the spoliation application? Well, we say no, it's not. They aren't. Well, they're not consent, they're not court orders, they're not statutory enactments. And so that should put paid to the defense, to the spoliation application. In other words, that should result in, we say respectfully, this court finding that there was a spoliation. What happened afterwards was there was this interlocutory that was brought. And the court obviously will, when Mr. Ruri is on his feet, the court will deal with him about the production of that evidence at this late stage. I simply want to say this: assume that the court finds that it will allow that evidence. We say, well, then their case is that goes to remedy. Essentially, I mean, we know that they say, well, it's a mootness case, but it can't be moot because, in other words, their expansion of their occupation after the court order by Makgoba and in particular the SCA, that expansion doesn't render the dispute dead. I mean, it remains live. The MPM have always maintained that they've spoliated, and they've always said, well, we've got an EA. So that's still the dispute, and it's live, it's still before you. So that's a bad argument, we say respectfully to our learned opponents. But what they do want is they do want the court so they do want the court to take into account what happens afterwards for the purpose of remedy. So they really are saying, we know that the default remedy for spoliation is restoration and ejectment, spoliation of a fixed property, so it's spoliation and ejectment. But we ask this court to consider what we did subsequent to the spoliation application. We expanded our occupation. We exacerbated, we say, the spoliation, and they don't say that. And so they say, take that into account and don't order restoration and ejectment. Well, we say, nothing that they've put up assists them. And the reason for that is, this court itself has said in Kumbula, that, Kumbela, I think it said, and in Schubert, it said that the default remedy is restoration. That's the default remedy. And we say, as we've argued in our supplementary submissions, we say that if one looks at the SCA and the Constitutional Court decisions on spoliation and the spoliation remedy, there's no room there for just and equitable relief, which is really what Nkwe is asking for. And the reason there isn't is because you can't, just and equitable relief doesn't come into it when there has been self-help. In other words, where there has been a fundamental infringement of the rule of law. So courts can't come to the assistance under just and equitable remedy. It can't come to the assistance of litigants who breach the rule of law. In other words, who don't go to court or don't themselves pursue internal remedies, whatever those might be. They don't do any of that. Take matters into their own hands by occupying without our consent. And then, when the court finds that they've spoliated, then say, well, help us. Come to our aid with under your wide, just and equitable remedial powers. We say, well, that you can't do that in a spoliation application, and you can't respectfully, Justices, because the default remedy is restoration and ejectment, and because just and equitable simply isn't suited to the situation where what you're asking to correct is a fundamental breach of the rule of law. In other words, you're asked to correct self-help. Well, the way that this court and the SCA and AD before it have corrected self-help is by ordering restoration and ejectment.
Mr. Brainders, good morning. My question relates to the spoliation application and the Modikwa's case in relation to possession. Because as I understand it, Modikwa only got to know of of Nkwe's conduct through reports in the media. So my concern is it your case that Modikwa had established occupation of the whole of the property, and if so, how did it do so? Was it just the fact that it possessed a mining right, it was a holder of the mining right from which it derived its rights to occupation?
No, it put up evidence in the papers that it had occupied the farm since 2002. And it says, in fact, it says at so it said not only that it held a mining right, that's volume 2, page 136. It also said, yes, volume 2, page 136. It said it owned a mining right over Maandagshoek. It said the whole of Maandagshoek is the mining area subject to its mining right. That's also volume 2 at page 136. It said that it is exercising its mining right over Maandagshoek. Also, volume 2, there was a paragraph 5.2. Then what it said was that it's occupied it since 2002, and I'll just ask my team to get that reference. And it said it has been there since. That's not disputed. The question whether it was in one part of Maandagshoek or another is irrelevant. And Bennett Pringle, which is referred to, that's the case referred, it's an Eastern Cape case. I think it was Adelson J. was the judge. It's referred to by our learned friends. That says, it makes precisely this point, that it does, and it relies, by the way, it relies on Ninabe versus Stuckey, the old AD case. And it says that you don't need to be in occupation of the whole of the property. In fact, Ninabe versus Stuckey, you'll recall, the cropper wasn't even in possession of the property at the time. That was a cropper who came there during, I think, ploughing and planting season. And that's when the cropper was there, and otherwise it wasn't there. And when it wasn't there, the gates were closed, and the cropper was prevented from coming onto the land. And Ninabe versus Stuckey said it doesn't matter. I mean, it's not that cropper didn't even have occupation of a part of the property. He just had rights to plough there. And our courts have been quite clear about this. You can't say, as a spoliator, well, I didn't see the occupier in that part of the property that I occupied. I mean, it's the same as saying that I own a house and it's got 3 bedrooms and I'm not occupying the 3rd bedroom. Somebody can walk in and say, well, I didn't see them in the 3rd bedroom, so I can occupy it. I mean, that's absurd, obviously. That's not our law. Their case that they didn't see us at the northern end of the property is irrelevant.
Thank you, Mr. Branders. My next question relates to the interdict. Is that if it is so that the High Court didn't consider the interdict, if it were necessary to get there, would you suggest that this court do so for the first time, or that the matter be remitted? And what would this links to my third question, which is the issue of delay. What would the consequences of that be for delay? Given delays to date in this matter.
Well, the papers, we say, sufficiently, it was an application, so it's not as though there's any further evidence. It's not as though there's any further evidence that can be put up. I mean, it's possible, of course, but one would have to seek the court's, one would have to seek leave from the court to put up further evidence in the High Court. But the evidence is there. I mean, we occupied, they then attempted to occupy, and they didn't give us notice. That's conceded. I mean, the question is that a breach of the Act? And if they didn't give notice, can they be interdicted? We say they can.
So as I understand you, suggesting the court would determine it for the first time here?
Yes.
And then in relation to the issue of delay, there have been many years now since this matter came before the High Court. Is there anything to be drawn from that?
No. Yes, I mean, there's well, well, what is more fool than no? I mean, it was a spoliation. It was self-help. The fact that there were delays doesn't help them. The fact that it's taken this long to get here doesn't help them. And the delays are, I mean, it's the nature of appeals and litigating appeals. I mean, things take time to get through the appeals system. So we're stuck with that. I mean, MPM says, I was the subject of self-help whenever it was, 2021. I took action straight away, and then there were these appeals, and can't be held against them. But I mean, they're entitled to appeal. It can't be held against them. The appeal only got here now. I mean, it's not there. It's not. The reason that the appeal is being heard today isn't because MPM delayed it.
Thank you, Chief Justice. Mr. Brandes, can you first give me the full citation of the Ninaba case?
Ninaba versus Stuckey, I'll give it to you now, is so it's referred to in our heads, but I do have it here in a note. Just bear with me. So Ninaba versus Stuckey is, yeah, it's 1946 AD at 1049. Yeah, there we go.
Thank you.
1946 AD 1049. That's the case of the sharecropper. Bennett versus Pringle was the case of the butcher. And you'll recall that was where there was a lease agreement with one butcher, but there were other butchers occupying it. And the lessor said the butcher to whom he leased wasn't in control of it because there were other people there and he wasn't in control. And similar sort of argument to this here, well, you weren't there. And the court said, well, they had control of the butcher.
What's the citation of?
So that's referred to, Bennett versus Pringle is referred to in there, but the citation there is 1977, volume 1, SA 230E. I mean, it says, it is not necessary that the possession be continuous, either by the claimant or his servants, if the nature of the operations which he conducts do not require his continuous presence. The possession on which he relies need not be of the whole property. That was Bennett versus Pringle, and it relied on Ninaba versus Stuckey for this principle.
Thank you. Could I then, on your main case, which is the question you pose for the court to answer is it a defense to spoliation that you have statutory authorizations? Is that correct?
Yes.
Now, there is a case of the Supreme Court of Appeal called Street Pole Ads versus eThekwini Municipality. Are you familiar with that case?
No.
All right. It's reported, perhaps you can deal with it after the adjournment. It's reported in 2008, volume 5, SA 290. It's a judgment by Justice Cameron. And he says that in a spoliation case, if an applicant goes further than the traditional grounds of spoliation and relies on the substantive right of possession, such as title to ownership or contract, then it is permissible for a respondent to enter the merits of the right to possess. And in that case, he said that it was permissible because what the municipality had done was not only to cite a spoliation, but also to go beyond the spoliation and to ask for an interdict. It struck me that that case is analogous to what we are dealing with here, which would then mean that Justice Makgoba was not incorrect necessarily in paragraph 53 of the judgment when he found that it was permissible for him to look at the right of possession of your client and the right of possession of Nkwe, both of which are competing statutory authorizations. So I wonder if you have submissions to make on that point.
Yes, and the submissions are, our case was never that so the case of MPM was that it relied on its occupation and a spoliation application. That was its case. The interdict case was simply, first it was in the alternative, and second it was simply a case of you've breached a statutory requirement, and if you've breached that, we're entitled to the interdict. So the case you refer to, the judgment by Cameron J.A., is not analogous because it's not an analogous situation. MPM didn't rely, for example, on a contract with Nkwe or anything of that nature. It simply said, well, we were in possession. Of course, the context of its possession is that it held a mining right. And it said, as a result of that mining right, we took possession and we were there. We occupied it since 2002, the property.
Well, isn't that the problem? That the possession is not a common law possession, it's a mining right possession.
No, but it doesn't matter what the nature of the possession is. In fact, it can even be illegal possession. If you're in possession, you're entitled to a spoliation application. So it doesn't really matter.
Yes. And the pleadings in this case also rely on the mining right as creating the possession.
No. So obviously, it's a,
Yes, could we? You're saying that they don't?
No, I'm saying this. Obviously, the context is not irrelevant. And what MPM did was it said, we're in possession. And we got there, we're in possession because this is how we got here. We got here through a mining right. And we're in possession, and we have been in possession since 2002. Well, assume
But 2002 is just the start of the mining right.
Yes, but it continues since then. It stays in possession.
Well, that's the problem I have with the case. The way it's pleaded, this is the point, it's not a new point, it's the point that Justice Savage put to you. The way the case is pleaded is that what was spoliated was the mining right itself.
No.
Well, perhaps you can help me to understand the pleadings better. If you go to the founding affidavit, which is volume 1. So, paragraph 3.10 of the founding affidavit. And then you go to the summary of the case, paragraph 4 of the founding affidavit. And then you go to paragraph 5.7 of the founding affidavit. And then paragraph 5.11 of the founding affidavit. And paragraph 10.2.1 of the founding affidavit.
Look
All
at
of those paragraphs suggest that the complaint about what is spoliated is the mining right itself. So that's why I'm saying maybe you can help me to understand these pleadings better.
Well, so, I mean, even a right can be spoliated. We know this. An incorporeal can be spoliated.
I accept that fully, but I'm simply trying to understand that your client's complaint was that what was spoliated was that right, but as a matter of law, it's correct that a right can be spoliated.
Yes.
Yes.
Yes. But its case is that it was in undisturbed occupation, and Nkwe took occupation of its mining area without its consent. I mean, that is the case. I mean, if those are the facts, then we say that's good enough for spoliation.
Yes. Could I then ask you a different point? Perhaps you can come back on this. I understand that. A different question. On the remedy itself, what we have with, even before this new application came, we already have enough evidence that the area basically had been built up by Nkwe. Is your case that the constitutional requirement of justice and equity doesn't apply to spoliation?
No, it doesn't.
I mean, I also struggle with that principle. Why would a spoliation not be tempered by the requirements of justice and equity, which are constitutional requirements?
Well, we set out in our heads why it wouldn't be, because we refer you to, is it the, let's find it in my head, it's the case of, it's the case in the SCA, sorry, no, in the Constitutional Court, I think. Let's find that. Yes, here we are. We say in our heads at paragraph, sorry, from page 15 onwards, courts can make just and remedial orders to resolve disputes over constitutional rights that involve social policy problems. And they may do so in a way that promotes the parties themselves. That's the word called the Ermelo case. There, the Constitutional Court says why it does this. So they may do so in a way that promotes the parties themselves offering solutions, and in a way that is practical through structural interdicts or supervisory orders. This approach was confirmed in later judgments, and we give you the judgment at footnote 25, I think. Now, we say that approach can't apply to a spoliation application because Nkwe provides a remedy that stops self-help. I mean, that's the remedy to stop self-help. There isn't a more just and equitable way of stopping self-help other than ordering restoration. I mean, how else do you stop self-help? Because, of course, what you've got to do then is the parties have got to go back, as it were, to the underlying situation where either their rights are resolved in court or by way of arbitration or by way of agreement, whatever. But until that, I mean, that can't happen at this stage. We can't get into a debate about how best do we sort of resolve this problem. That's not the purpose of spoliation or spoliation remedies. Its purpose is to resolve one and one problem only, and restore ante omnia, so that the parties can then pursue whatever remedies they have in law.
Thank you, Chief Justice.
I think, sorry, forgive me. I was going to say that I think I've overstepped my time, but.
Oh no, I won't. I won't be long. I just want to understand the applicant's position in relation to jurisdiction. You say that the error by the High Court was to find that the statutory authorization constitute a valid defense. And that's what you say is the error of law, is that right?
Yes.
Is that the...
Yes.
But now in your, and then you say the SCA did not consider that issue. Is that the complaint?
Yes, because what the SCA did was, well, I've already submitted that. It simply said you relied on hearsay material and you can't, that's the end of your case.
All right, and then you say the High Court Act finding that the statutory authorization do not constitute a valid defense, do not accord with the applicable principles to spoliation applications. Is that?
Yes.
And then if that is the case, why would this court have jurisdiction if it's just a misapplication of the law?
Well, it's an error of law, firstly. And secondly, as I submitted in response to Justice Matopo, it raises a rule of law question, which is self-help. And this court always has jurisdiction over questions of self-help.
And why do you say it's an error of the law?
It's an error of the law because it is not a defense.
Because in law it's not a defense.
Yes, it's not a defense in law.
All right, thank you.
Thank you. Just one or 2 points from you, Mr. Brainders. When I look at paragraph 5.7 of your founding affidavit, it seems that the applicant anchors its entitlement to the relief on the mining right, but then goes on to expand what it derives from the mining right. That's the right to enter the property, to conduct operations, which all appear to suggest that from the mining right it derives the possession that it seeks to protect. Do you have any comment on that?
Yes, so it doesn't need to prove that it's the lawful possessor. It can simply prove that it is in possession. But proving that you're the lawful possessor doesn't deny you a spoliation application.
Sure, but would you accept that reliance on the mining right in itself, and I'm not suggesting that's the case for the applicant, may not be sufficient?
No, it is sufficient.
Just having a mining right?
Yes, if you spoliate my mining right, that's spoliation. It's the same as spoliating my right to electricity, water. Incorporeals can be spoliated.
Okay.
I mean, that's our law.
So on that basis, someone who's issued a mining right but doesn't undertake any activities in terms of the mining right would still be entitled to the same remedy?
Well, I can't think of obviously one would need to look at the facts of every case. But in theory, obviously it is possible to spoliate a mining right. In this case, what they say is, it's true that we're mining, I think, the southern end, and we're moving towards where Nkwe exfoliated. You'll see from the diagrams, the locality plans, you'll see that there are those two reefs, and they plan to mine. They go all the way down the property, and they're planning to mine that. So they have a mining right over the property where those reefs extend all the way underneath where Nkwe is set up. Well, I mean, obviously they've spoliated our right to mine there, because it means that we don't have. So our right is that we can enter there and start mining there. We can sink a shaft there if we like. We can do whatever we like there in relation to our mining right. But once somebody sets up above on surface, well, that's an interference with our right there.
Okay, good. Lastly, on the question of the duty to pursue internal remedies, as I understand it, Section 96 of the MPRDA really deals with creating a prohibition on going to court unless you're satisfied, but that's in respect of administrative decisions taken. As I understand it, your issue is not with the EA or the WL. You might have an issue with that, but that's not the relief that you were seeking in the High Court. And so you have no dispute, as it were, with the department in terms of reviewing any administrative decisions they took in the mandament. Your issue was with the first respondent.
So, Justice Collipin, you make a very good point, which is one that I should have and didn't make, and that is that, of course, when one talks about pursuing internal remedies, one talks about pursuing internal remedies principally in relation to what statutory authorities do or don't do. In this case, we're not, so our beef is not with the statutory authority. We're not in dispute with the department. We're in dispute with Nkwe.
That's simply how I saw it, and even if you did pursue that remedy, the department could not make an order directing Nkwe to vacate the property. Okay. It would extend beyond their powers, not so.
Correct.
Take an early adjournment until, don't trust that watch, until 1:15. Hello, everyone. Please, let's get ready. And please, no food are allowed inside the court. Thank you. You had finished, right?
I had, yes, those were my submissions, unless there were any further questions.
Okay. And what relief do you seek from us?
The relief is uphold the appeal.
I struggle to hear you, Mr.
Sorry,
Brandes.
I beg your pardon. It's to uphold the appeal and replace or substitute the order in the High Court with an order granting the spoliation application and ordering restoration and ejectment. As I understand it, we put up a draft order.
Attached to the heads.
Yes.
Okay.
And in the draft,
And you seek costs.
yes, costs,
Okay.
of course. In the draft order, we said that, and this is, of course, where you can exercise your discretion. So when ordering ejectment, of course, you can, as the court, you can say, well, you reject it tomorrow or in a week's time or 2 weeks' time. Because of because what has been established are fencing, officers, roads, I think in our draft, we say that it would, granting an order that Nkwe vacate within 3 months after the date of the order, we say would be a fair order.
Thank you. Mr. Roux?
Thank you, Justice Maya. Since the proceedings in the court Aquo in June of 2021, some 5 years ago, this case has been reformulated and it's been elevated, impermissibly so we submit, into a question of whether Nkwe's extant statutory and administrative authorization, that was the EA, the water use license, the EMPR, and the social labor plan, the SLP, lawfully permitted mine support activities on a defined portion of Mandagsoek. If I remember correctly, it was some 300 hectares of the overall 14,000 hectares that comprises the mining right, in support of Nkwe's mining right on the adjacent farm Garatou. This question, we contend, cannot be resolved through urgent spoliation proceedings that were launched on the premise, and that was the challenge, correctly referred to by learned acting Justice Nkwe in the founding papers, that no authorizations existed for the carrying out of the activities as it was done at the time. And then there's a recast in reply, and that's what the learned Justice Makgoba also said. You cannot make a case in your replying affidavit, because then the whole emphasis shifted. And then charge validity and effect of those administrative decisions, which perhaps at the outset should be said. If an activity is listed, for instance, to build a road, how do you build a road if you cannot come onto the land? That coincides, we say, for parity of reasoning. Those listed activities can only be carried out if you go onto the land to do them. It's absurd to suggest that because the activities say build a road or build a dam, that it doesn't allow for possession, for occupation, to go onto the land and do what you need to do in order to achieve the outcome of that listed activity. For purposes of our argument, we will do so, we believe, in three logically distinct stages. We will deal with the Rule 11 application and ask the court to admit the later evidence for a very confined purpose. We will then deal with the merits that falls to be decided on the 2021 record, what Modikwa pleaded and what Nkwe provided in their answer, together with remarks on the shift, the impermissible shift in reply. And thirdly, we say if Modikwa surmounts some of the hurdles, then only does the question of present-day relief arise. Keeping the stages separate prevents supervening events from retrospectively deciding the merits, whilst ensuring that any order, if it is granted, is not divorced from the present reality. Firstly, we deal with the Rule 11 application. The further evidence establishes facts that did not exist, it could not have existed at the time, or were incomplete, when the High Court in 2021 and the SCA in February 2023 decided the matter. The completion and operational use of permanent infrastructure, expenditure of more or less 150 million later, and the surface lease concluded with the state on 29 September 2025. We say that these facts are not tendered, and they do not rewrite the history or validate Nkwe's entry retrospectively to have carried out those listed activities. It is tendered because the SCA judgment in Mabotwane requires practical effect to be assessed as at the date of the hearing of the appeal, not as at the date of the original order. And thus, the court should not undertake the inquiry while assuming that Maandagshoek remained as it was in June 2021. The subsequent facts presented in the Rule 11 application, I don't believe it's seriously disputed because the photographs are there and there's an admission that these infrastructure elements exist. You say, but they show that 5 years have passed since the learned Justice Makgoba JP, as he then was, decision, when he dismissed the urgent application, and over 3 years since a unanimous SCA decision, Per Karelse speaking for the court, dismissed the appeal. And neither court restored possession, ejected Nkwe, or restrained any construction pending an appeal or otherwise. Meaning, in simple terms, justices, if any order is made ejecting Nkwe, then it draws a line through an extant administrative decision that was enacted and found its way to the EA, the Water Use License, the Social Labour Plan, the EMPR, and we call that the backdoor review, and I'll get to the internal remedies mentioned by Justice Kolopen. And you will be well aware of the fact, and we've made that point, that there had never been any internal appeal, such as provided for in Section 96 of the MPRDA, and following on that, any review that has ever been sought against those administrative decisions that are extant. Construction continued, as you would have seen, until December 2024. And what Nkwe established there can only be called mine support infrastructure for purposes, as we said, serving the mining right next door at Garatau, which cannot be mined in any other way if those listed activities did not exist and allow for them to build their infrastructure there. Nkwe concluded their surface lease with the state, binding only those parties until such time that it is notarially executed. Of course, it's inter partes valid between them. But that confirms that the occupation and the buildings are neither casual nor clandestine. As required of a litigant, the position now, particularly in spoliation proceedings, should be what is the lay of the land as it now stands, particularly because of the delay. We are not saying that the delay should be attributed to anybody, but the delay is a factual issue that needs to be considered. In railway commuters and Coleman and Dunbar, there was a requirement that a satisfactory explanation be given by the litigant wishing to introduce further evidence, and that be material. We say both are present. The subsequent facts bear directly on a question whether restoration, ejectment, or demolition can produce any effective result, and that question cannot be decided on an artificial 2021 premise, we submit. There are third parties, employees, mining contractors, and the likes that are also influenced should such an order be made. We say Modikwa suffers no real prejudice with this application. It has answered fully. In fact, it went a lot further than an answer to the simple introduction of those facts necessary for the exercise before this court. We say again, they make allegations of aggregated spoliation, and they've introduced 4 new causes of action that we could see from their papers. And that is impermissible. They would allow this court to sit in a way as a court of first instance, which should never happen. It wasn't their case. In the founding papers, what they refer to now in their answering affidavit to the Rule 11 application and their heads of argument, and they should be kept to the original set of pleadings which allowed for this appeal to exist. We say exclusion of this evidence, by contrast, risks an order built on obsolete facts, potentially requiring the demolition of environmental control works. The evidence is therefore submitted solely to inform any possibility of present-day practical relief and not the 2021 merits. That's the Rule 11 application. We stand with our heads. We believe we've comprehensively dealt with the reasons why that evidence should be admitted for a very concise purpose. The next would be revisiting the 2021 merits if leave is granted on appeal, and we'll deal with the leave in due course. We contend, first and foremost, as we said in our head, it remains a question of pleading. My learned friend was referred to the record. And the record poses an interesting challenge in the founding papers. The appellant relied there on their mining right, but what they said was, Nkwe, you don't have any environmental authorizations or any right to do what you're busy doing there, and you have not given us notice, and you don't have the consent of the landowner or those maize farmers that exist there. That was their challenge, and perhaps from page 16, paragraph 3.10, up to page 20, with the summary of their case as it appears on page 20, lodges or launches the challenge with which they approach the court a quo. And it's instructive that what they said in their summary was that my client spoliated them because their rights is a mining right over the area in which they have been in lawful, peaceful, and undisturbed possession since he's acquired the mining right. But in due course, we will argue that some physical possession was needed, because who was in possession was common cause. It was the 185 plus maize farmers busy cultivating the lands, the surface area, which are affected by the environmental authorization, and whose permission the my client got in the form of those compensation agreements, and they also informed the state, who is the landowner and with whom they have concluded their lease now. So it was very clearly a case that directed a challenge that was properly answered, and that's what the learned Justice Makgoba ultimately found. And the learned Justice Nkwe referred to the case, I believe it was Cameron J.A., that made the finding that when applying for spoliation and going further than just the two requirements, you allow for your opponents to deal with the merits of the underlying disputed rights. That's exactly what happened here. Because the interdict, as an alternative, required of them obviously to deal with interdictory relief. So their challenge was met on both fronts, both in respect of spolie, but dealing with the underlying merits because it was allowed to do so because of that finding. There's also a judgment in the Gauteng division, Sand Parks, and I can't remember, I tried to remember the citation. If I get it, I will inform the court. Saying, similar to what Justice Cameron said, if one chooses to deal with the merits, then you allow your opponent to do the same. And we say it's the same set of facts that we are faced with here. We say Modikwa did not plead that those existing authorities, the EA and the likes, were either invalid or exceeded the decision maker's powers or could not authorize Maandagshoek activities in support of the Garatau mining right, nor did it seek a review under Rule 53. If they had relied on their mining right as they do, and there is some element of an opponent that causes the mining right to be distressed because of their Section 5 rights, which they can exercise on the property where they hold the mining rights, Section 96, even on an urgent basis, is available as an internal remedy in terms of the MPRDA, and it's well known that internal remedies ought to be exhausted. What could have happened was that the RM, the regional manager, could have been involved because complaints against your mining right is usually dealt with in terms of Section 54 of the MPRDA. And the RM had the authority to order the activities to stop in terms of Section 54(6) of the MPRDA. Yet, no such relief was ever sought. And you must remember, Justices, that the public participation process that ultimately led to the issuing of the environmental authorizations and what followed on that was participated in by Modikwa all along. When it was issued, apparently it was no problem until such time that it became a problem. They cannot hide behind their failure to have launched an internal appeal or reviewed ultimately, if needs be, and do a backdoor review now, or as it did then in 2021. We say, but more than that. That is the participation in that public participation process. The state's written consent was obtained, the consent of the lawful occupiers who were in physical occupation and were cultivating the land we got, but also the community leadership. Amongst others, there are 5 directors, not 4, 5 directors, of the JV partners of Modikwa themselves. Those are the facts that we pleaded. If in law it constitutes tacit consent as we contend in law, then that is a valid argument to present to the court. We say those authorizations that we had preceded the alleged dispossession, covered the relevant footprint and allowed for the activities and followed prescribed statutory process. you would have read, Justices, that took almost 8 years to complete before the EA and all of those were in fact granted. Now, only in reply did Modikwa change its case, contending that the authorizations were insufficient because Nkwe's mining right related to Garatau and not to Maandagshoek. Well, that fact was known when the EA was in fact issued, because it was common cause on the papers that what was needed to mine Garatau next door, which is a mountain, was the activities and the infrastructure to be created on Maandagshoek. The relevant authorities, both from a NEMA environmental perspective and that of a mining perspective in terms of the MPRDA, must have been, and it shows that they were acutely aware of these facts when ultimately authorizing the listed activities. We say, it's a simple answer to that, it's a question of coexistence. So this, in the reply, posed a new public law challenge to the validity, the scope and effect. And as we know, and we submit under Oudekraal and Kirkland, those decisions will remain valid and effective until set aside. Without repeating my initial argument, if there is relief, it will draw a line through authorizations that were never challenged in law up to this date. And we say you cannot avoid review and nullify them through spoliation. It's as simple as that. Now, dealing with the elements of the monument. Modikwa's central position is that the only defenses to the monument are a statutory enactment, court authorizing possession, consent of mining right holders, or the impossibility of restoration. That's our summary. Further, they contend that the EA and the WUL, the water use license, is not a statutory enactment authorizing occupation. We've dealt with that. First, as to unlawful deprivation, the monument requires deprivation that is wrongful. That is without consent or lawful process. We say, well, that process was participated in by them before the EA was in fact issued. It's not merely deprivation suffered by a party such as they contend holding a superior right, which they say is their mining right. Impala water users requires a party relying on statutory authority to show that its conduct fell within that authority. Nkwe just charged that burden. Its possession and activities were authorized by the extant administrative decisions taken after a lawful process and in which Modikwa participated. So they acted with recourse to the law and not by self-help. Secondly, and independently, as to peaceful and undisturbed possession, their mining right did in itself not establish factual possession of every part of Maandagshoek. One would have expected some sort of control because it is an incorporeal right. Who was in control of that property was the maize farmers. It's as simple as that. Modikwa's operations, it's common cause, it was kilometers away from the surface area where they have their 3 decline shafts and all of their infrastructure. That was a common cause fact. And they mine at the depth of 450 plus meters underground. Not affected at all by the top structure surface activities. We say Nkwe entered with the consent of those actually possessing in some or other physical way, together with the state as the owner, and using the footprint only to the extent allowed for in the EA. We say Modikwa therefore failed on both requirements of the monument. It neither proved factual dispossession of the footprint nor any wrongful deprivation. We say it's not about fragmentation, but coexistence. In any event, we say under Plascon Evans, rightfully pointed out by the SCA, and we believe adopted by the learned Justice Makgoba, under Plascon Evans, Nkwe's version had to be accepted without an interrogation into further issues there. The alternative interdict. Modikwa, in the alternative, sought ejectment and the removal of all fencing plant, equipment and structure. But we say final relief was competent only if our version justified it together with the admissions. And our answer to that is very simple. The EA, extant as it is, together with all those other administrative authorities that we possessed, was done after due process, including public participation in which they participated. They established no clear right to eject Nkwe or to remove the infrastructure. If it is disputed, the validity or scope of the authorization, their remedy lied elsewhere, not in spoliation or an alternative interdict. Because that, the final interdict, treated extant administrative decisions as ineffective without setting them aside. Further, Nkwe did not manufacture any mootness. That is their contention. My learned friend has not argued the whole constructive contempt that they raise in their answering affidavit. We say in any event that is wrong. Because neither the High Court nor the SCA ever restrained any form of the listed activities that are extant. They didn't obtain any interim relief pending the appeal. If it was a requirement that my client should have been wary of an appeal or this court's decision, then what was the purpose of dismissing the relief that they sought? HEG consulting concerns intentional non-compliance with operative orders. It does not create contempt where no order exists. Pending proceedings do not restrain apparently lawful conduct. Only a court order does. Should the court ultimately, and in the alternative, grant any form of order, we say restoration is no longer available. Because what changed substantially. It is not the case where a billboard can be handed back in more or less the same the word escapes me. Condition, more or less the same condition. Sorry, it escaped me there for a moment. Nor is it a case where, such as happened in Tswelopelu, exercising constitutional remedy to hand back something in another form that may be dismantled if necessary at the end when the underlying issues are sorted out. We say, well, third parties are also involved here because there are employees and mining contractors using that which was lawfully established on that piece of land, and the permanent structures as opposed to temporary structures now exist. Dams, waterways, buildings, brick and mortar, and the likes. We say, as Normandin Farm holds, courts should not decide abstract or academic disputes. That which existed at the time in 2021 are no longer the same and was never done unlawfully. The other case that may be relevant is that of Ivanov. The seized equipment could be returned in substantially the same condition. That was the requirement. Here, it cannot be done. We say, this court ought not to order reconstruction because that is not restoration. Restoration would be tantamount to the backdoor review that we have submitted because the relief they seek would require nullifying the Nkwe statutory authorizations. That's the simple part of it. In conclusion, we say on a holistic view of the case, no constitutional issue has been raised. The issues that were raised, in fact, is really a disappointment with a judgment without setting forth the grounds how a Section 34 right was in fact violated by either the SCA or by the court a quo. We say the simple application of Plascon Evans on trite spoliation principles, together with the judgment by the learned Justice Cameron, which made it not that simple, but still easy to apply, the Plascon Evans principles, does not give rise to a constitutional issue. Section 34 guarantees fair judicial determination, not a favorable outcome, nor a separate determination of every argument where one finding is dispositive. So why did the learned Justice Makgoba not deal with the interim interdict? Perhaps because the first point was good enough to dismiss the application, which he did. That is a simple practical answer to that. And why did the Supreme Court of Appeal not deal with other facts than an obvious finding which was not made by the learned Justice Makgoba, but trite principles of admissibility of evidence relied on? And whether right or wrong, in that instance, it was a factual decision that were made, premised on principles of evidence. And Plascon Evans also played a role there, because similar to Justice Makgoba, they accepted that there was a challenge that was met, and that version could not have been rejected. What we asked for was that the Rule 11 application be granted and the new evidence be introduced, and that leave to appeal be refused. Alternatively, if it is granted, that the appeal be refused with costs of due counsel. And that's our argument.
Mr. Roux, let me start at the end of your argument. This relates to the expenditure incurred by Nkwe post the Supreme Court of Appeal, which you estimated at 150 million plus. And your argument was that that should be taken into consideration when an evaluation is made about the rights of your client. If this court were to find that your conduct in the beginning was unlawful, would you still persist that this court must consider that in its evaluation?
Well,
in other words, if this court finds that you spoliated, let's put it that bluntly,
if the finding is that my client acted unlawfully, then obviously the further evidence of the expenditure creating a new landscape only becomes relevant when it comes to remedy. And the amount was never meant to have any other meaning than to say a large amount of money was spent on creating something lawfully that you see now. It is not a simple small house that was built. It is large infrastructure.
So you would reckon that should be taken into consideration?
If the amount is not taken into consideration because it is substantial, then what was created, which is common cause, that is the important issues that should be considered, we submit.
If what was created unlawfully, you would still request this court to come to the aid of your client on that basis?
Justice Matopo, it's a difficult question because I can only answer it in one way, and that is, if this court finds that the listed activities that was carried out prior to 2021 June and thereafter up to 2024 was not allowed for in the environmental authorization, then one could live with unlawfulness until such time that those decisions are no more. They are either reviewed or internal appeals succeed or otherwise.
I don't understand you.
We submit it cannot be found to be unlawful because
At what stage would you contend that we must make the determination about the lawfulness or otherwise? Would that be at the stage of the determination of the spoliation or not? Maybe that's where I don't understand.
Yeah. Perhaps I should rephrase it as this. Lawful dispossession occurred in our submission and not unlawful dispossession as a result of a statutory process that led to the EA. If there is a finding that there was an unlawful dispossession, we submit that there can be no such finding. Because independent from any finding on spoliatory relief, the landscape, how it is now, affects remedy. And it does not rewrite the history of the record as it was in 2021. That's the best answer I can give.
There's an answer to that. It's a judgment of this court which was delivered last week penned by my brother Kolapen relating to exploration rights. It is in paragraph 144 and 145 of that judgment. Don't worry, I'll just read it out to you. And you'll tell me whether you associate yourself with those remarks. Unfortunately, they are binding. It says, it's apropos the question that I raised with you about the lawfulness or otherwise. The judgment says, where a party has played a role in contributing to the unlawfulness, their interest necessarily carry lesser weight. This is implicit in Bangwenyama, where this court held that Genora, who was also a party in these proceedings, had been aware from an early stage of the community interest and stated that, quote, any further prejudice it suffered knowingly. The High Court in Adams put it more pithily in another context where there was improper notification and consultation. Ozenzile agakhalelwa, which the court translated as self-inflicted harm deserves no sympathy. Another interpretation would be you take responsibility for the consequences of your action. And this court said, I see no reason why this court should not make a similar order here. The distinguishing factor is a moratorium. In my view, undue weight should not be ascribed to the moratorium. So the ratio of this case seemed to be against you as far as the cost is concerned. In other words, you are the author of your own misfortune. And if we find that you are the author of your own misfortune, unfortunately, following this judgment, this court cannot come to your rescue. Have a look at it, and then you'll see your junior may indicate to you how you respond to it. I still have another question that I want to ask you. I thought I should just put that up front.
Justice Matopo, we are obviously bound by that judgment. I have not read it. If it's on all fours with the facts, then we are bound by it. We maintain our argument that we will not be found to have self-inflicted harm where the pleadings resolved the case initially, and no subsequent events will change that to unlawfulness because of the extant EA, etc., that existed at the time. That's our argument to that.
The other issue that I want to traverse with you relates to the listed activities, the statutory authorization and the listed activities. In the definition of the Act on the NEMA, the listed activities are described as, when used in Chapter 5, means an activity identified in terms of section 24 subsection 2A and B. What I want to find out from you, whether the listed activities that are in the Act are on all squares with the conduct of the respondent in this case. In other words, can we find that the conduct of the respondent in this case falls within the listed activities that are described in the Act?
The answer to that is emphatically
And where do we find it?
yes. It is firstly common cause that my client has not transgressed the authorizations issued under NEMA. It was attached to the papers. I recall it starts in volume 3, page 226.
I'm using case line, so
It was annexure.
but where do I find the listed activities from the Act itself?
Well, from the Act, it translates into the document that is issued as the environmental authorization, that which is allowed for in terms of the Act, and that you find from page 228
Hold on.
of the record, and the
Just
listed activities appears on the left-hand side.
Do the listed activities permit occupation?
Yes, they need occupation to be carried out. How else will one build a dam, for instance? But what I can submit to you is on page 179 of the record.
No, I need to be on the same page with you. And I've been directed to the listed activities via case line. And which ones would you say are relevant in this case?
Oh.
Which listed activities? I have them here on my screen.
Well, it will involve. and I will-
What's the page number again in the hard copy? Here.
In the record, the summary is obviously on page 179.
Okay.
17 volume.
This is in volume 2.
True, thank you.
What this describes is really the summary of what infrastructure was needed, and there you find all of the activities such as a processing plant, stockpile areas, waste rock facilities, tailings facilities, sanitation, electrical services, substations, haul roads and stormwater canals, and dirty water management facilities.
So you
But then
would
if you-
contend that all these activities cannot be undertaken without occupation?
No.
Otherwise, it won't make sense.
Well, if you can't go onto the land,
Exactly.
you cannot build. And we say it is cynical to suggest that if you are, for instance, if I may read one of the activities, on page 229 of the record, it is GNR 544 item 12, for instance, just by way of identification. The activity here is listed as, quote, the construction of facilities or infrastructure for the off-system storage of water, including dams and reservoirs with a combined capacity of 50,000 or more cubic meters, unless such storage falls within the ambit of activity number 19. So in order to be able to do the dam and the reservoir, you have to enter the land to go and construct it there within the area that is showed on the map.
So,
that shows the
and
locality.
entering the land, which is not your land, because your right is adjacent to that land
Yes,
for the purpose of the activities that are listed.
yes.
Would you require the consent of the landowner, land occupier? And if so, did you seek and obtain those consents?
We got the state's consent, that is common cause.
Like your landlord, if you see,
Sorry, I did not hear.
like your landlord in a leased property.
Yes, but at the time, in 2021, we proved the consent of the state.
The state.
Which is the landowner, and we had the lawful occupier's consent in the form of compensation agreements with the maize farmers who has physical possession of that 300 hectares, more or less, that piece of land where we enter to carry out those activities.
And
also, we had, as we suggested, we had 5 of the directors of Modikwa's JV partners consent, who are the community leaders in that exact location on Mandasuk. So that we contend later on. It's a question of law to say there's tacit consent, and we do contend that.
So a holder of a mining right, like Modikwa, his consent was not sought and obtained, except for those consents that you've listed.
I'm terribly sorry, I
no,
don't understand
I'm
the
saying
question.
you have listed the individuals from whom you obtain consent. And out of those individuals, Modikwa's consent was not obtained except for those 3 or 4 or 5 directors, which you say constitute tacit consent.
Yes, it's one of the partners in a JV, or a partner in the JV, that binds the partnership.
No, sorry, I don't understand you there.
If I get consent from, if there are 2 partners, and I get consent from one, the one binds the other partner. But it goes a bit further than that also, Justice Makopo. One must remember that Modikwa, if we talk about them as a legal entity, through one of their duly authorized representatives, participated in the public participation process that led to the granting of the EA.
But that means nothing. Anybody can participate in a public participation, but it does not necessarily mean that having participated in the public participation, implicitly it grants you the authority and the permission to occupy the property. That's a different process altogether. We may agree at the public participation that in the fullness of time, we will allow them, but doesn't mean when you occupy, you are allowed, or you had that authority. It's something else.
I respectfully disagree.
What seems to be more compelling on your argument is the compensation compensation farmers.
The maize farmers.
I don't
the
think
compensation agreements.
Compensation agreement. The directors, whether they are renegade director or not is something else, whether they have the authority or not. The landowner, which is the state. But what is troubling me is Modikwa as an entity was not consulted. And the Act says it must be given 21 days notice. It's a land occupier, as a land occupier.
A land occupier, we submit, was those physically occupying the land with the intention to derive a benefit as required by our law, and that were the maize farmers. Modikwa had a mining right. They were busy exercising that mining right kilometers away where they use land. And that's not this, so we say we need not inform them in terms of the Act. We didn't need their permission or had to inform them and give them 21 days notice. That's our case.
Okay, thank you.
On all the submissions that we made in our heads, I just summarized it to an extent. And perhaps I may just, if I may just add one aspect to the debate, Justice Matopo. During the public participation process, what was the issues discussed was obviously those that resulted in the activities that were listed, because that's what the EA was all about. And there was never an objection from Modikwa's side about those listed activities. To now contend you cannot come onto the land because the activities does not involve occupying, we say that's absurd. It cannot be interpreted in that way purposefully, the EA and the listed activities.
Mr. Ru, I want to just deal with your argument on exhaustion of remedies. My understanding of Section 54 is that it applies when the occupier prevents the holder of a mining right to enter or conduct operations on the premises. In this case, the occupier did not prevent the holder because the occupier, that is Modikwa, was never asked. So there is no basis for you to then say Modikwa must then exhaust internal remedies, unless I understand Section 54 incorrectly. It seems to me to apply to a situation where a holder has been prevented, and it's the holder would then have to go to the regional manager to complain against the occupier.
Our argument is that Section 54 does not only, in a purposive interpretation of the MPRDA, allows for a holder to complain to the regional manager only if the landowner, for instance, or occupier, refuses entrance. It goes further. Because the Section 5 activities that may be exercised by a holder is not only to enter upon, but it is also ancillary related mining activities. And that purposefully interpreted, we say, if there is a complaint, not about access, but we cannot exercise our surface mining and ancillary mining related activities because there is an occupant doing what we want to do, then that Section 54 can be interpreted to mean that the RM was the correct person to approach to complain, because otherwise the RM has no statutory function, the mediation, the arbitration, once he has found that one or the other party may have acted unreasonably within the context of Section 54. So we say it's a bit wider than that interpretation.
So you're saying your occupation of that 300 hectares, what Modikwa should have done is to then go to the RM to say, Nkwe has now occupied an area which we would ordinarily have had a right to mine, but because of their presence, we cannot do so. Is that what you are saying?
Yes. And there's urgent remedies that they may have obtained in doing so. Because one must remember, the RM would have had the function to hear the complaint and then ask representation on my client's side. And my client would have presented, much as he did in the urgent court, the extant administrative authorities, and then he had to take a decision on that. And that may have ultimately even led, if he didn't refuse Nkwe to continue with their activities, because he was also then persuaded that they are acting lawful and not unlawful, that there may have been an urgent review of such a decision. And that was procedurally what should have happened, we say.
Coming back to the question that was asked by my colleague Justice Matopo, question of consent by the occupier. Why, you have said, why did you not approach Modikwa? I know you're saying we were operating on a small area and they were far away, but it's one area, it's basically one piece of land, Mandaksuku. And we know that Modikwa has the mining right in respect of the entire area. Why did Nkwe not approach them for consent instead of going to the other people, that is the 5 directors, and Modikwa says they don't have any authority to bind them?
The question as to why can best be answered from the record. Those that were in physical possession, that is the requirement, because that is what is restored by a spoliation. For purposes of the 5AC question about notification, those that were in fact in physical possession, they were notified. They had to have compensation agreements because the activities cannot be carried out with those physically in possession, busy with their farming activities. The state owned the land. The evidence was, at all relevant times, there was an oral agreement between them as to the lease, which ultimately last year, September, was finalized. So I cannot answer why, but to say, well, it wasn't necessary to notify them because you must remember, Justice Mhlantla, my client never intended to mine Mandagshoek. They don't have a mining right there. They intend to win minerals on Garatau. And only if they had the mining right or thought they had or contended that they do, because that was the challenge, you have no rights. If they had a mining right on Mandagshoek and there was a competing mining rights, then obviously the obligation to notify exists. But if they're not winning minerals there and the activities is authorized by the EA, then in terms of the MPRDA, they have no obligation to notify a mining right holder, not by fragmenting possession in any way, that peacefully mines 5 kilometers or whatever further with all their infrastructure and their 3 decline shafts, and they conduct their mining underground at 400 meters. We say in our heads, as we do now, it is a case about peaceful coexistence, not destroying any form of competition in the platinum mining industry. That we contend in our paper seems to be the case. Why they keep on, even at this late stage, why they continue with this type of application. That should not be countenanced.
Coming to the application, you say there was nothing that barred you or prevented Nkwe from conducting the operations and putting in the infrastructure after the SCA judgment. But surely when you were aware that Modikwa had lodged an application for leave to appeal in this court, and ordinarily litigants would not do anything pending the outcome of the matter, why did Nkwe decide to proceed and invest, put in all these facilities and infrastructure, whilst well aware of the fact that the dispute between the parties has not yet been finalized before the courts?
To have halted or stayed any building processes would have signified adherence to an order that was never granted by 2 different courts. What's the purpose of the dismissing of an order in the court Aquo and in the SCA? There's always risk, Justice Mhlantla. I accept that there is risk. But when 2 courts have refused any final or interim type relief pending any appeal, then surely it is not any form of, at the one side of the coin, constructive contempt, or on the other side, adherence to what was never ordered. The balance is somewhere in between. And if Modikwa contended that their application for leave to this court has prospects of success, as a result of which interim orders should be granted, they should have brought that type of application. They never did. That's our legal answer to that.
Now that you are here, what would be an equitable remedy under the circumstances on both sides, if we are with you or against you?
dismiss the application and dismiss the appeal, but perhaps
If you are against you, what should we do? If we find that spoliation, High Court should have granted a spoliation order and instructed the parties to deal with the issues properly,
Justice
what would be the
Nhlanhla, I find it very difficult to make concessions, but if I have to, then probably my learned friend may have suggested something along the lines that the parties be ordered to submit themselves to arbitration for purposes of resolving the occupancy and or monetary dispute that may result from such occupancy.
I'm not satisfied with the answer here. The answer you gave to DCJ Mhlanhla's question regarding Nkwe's failure to obtain Modikwa's consent. Modikwa's mining right covers the entire farm. Now, surely if an entity comes and takes over part of that piece of land, be it for mining proper or conducting some mining or other activities, that must take away from the mining right, the preceding mining right, which the occupier who's already there enjoys. Is my understanding incorrect?
It is.
Why?
Because the common cause facts show, and it was pleaded in that way, that they have a mining right, they have infrastructure supporting their mining right, and 3 decline shafts that they have had and has mined since at least 2002 at various depths of 400 plus. So there was no, and I emphasize this, had their case been that they have a mining works program that shows their progress towards our side, or was that an alive issue at the time in 2021, which it was not with respect? It would have been viewed perhaps differently, but they never proved any statutory or otherwise progress in terms of the mining issue where they needed the infrastructure where my client occupies and carries out listed activities. And those listed activities, with the greatest of respect, justices of this court, they may very well create tension between that which was listed in terms of NEMA and the Section 5 activities. But that was not the case that was pleaded. That is something for discussion and argument on another day. Because the EA allows for listed activities that may or may not be defined as ancillary related mining activities by its very definition. And if that is or creates tension with the Section 5 talking about ancillary related mining activities, that's a case for another day. It was never pleaded in that way. Otherwise, the affidavits would have looked different, obviously, at the time. And to answer your question directly, one needs to give notice to the landowner, which we did, or, even if it's one or the other, or if it's both, a lawful occupier. Occupier in the physical sense of the word, we argue. And that was exercised, physical possession, occupation by the maize farmers. That's why it was important to recognize them. That's our case.
Thank you, Mr. Roux. In response to a question from the Chief Justice, you said that Modikwa had sunk 3 shafts quite far away from where you had conducted these activities. Had they given some indication that they were planning to undertake some activities there, it could have been quite different, not so? That was your answer. I'm just paraphrasing that.
Yes.
So are you saying that because they didn't say anything, somehow that gives you a greater entitlement, as it were?
It gave us a greater entitlement to have resisted spoliatory and interdictory relief in the court a quo.
Yes,
because
but-
that was not their case.
Sure.
If it is now their case, it's impermissible.
No, sure, I'm not saying that. So you accept as a matter of principle that the mining right would have granted them rights in respect of the entire property? Sure.
I must concede it's
Sure.
over 14,000 hectares, which include this, that
exactly.
is the case.
And it would be within their legitimate powers to determine where and when to conduct their mining operations, not so?
In terms of Section 5, yes.
Good.
But
So-
then the facts should be considered, which was common cause at the time, was they conduct peacefully their mining elsewhere.
No,
And
sure.
it was the case, now it is framed as fragmented possession, whilst our argument was no, there's peaceful coexistence.
If you accept the proposition that they were entitled to conduct their mining activities anywhere in respect of the area in respect of which they held a mining right, would you not think that at the very least it would have been prudent to inform them, given your understanding and your explanation today of your understanding of the scope and extent of their right?
I cannot make that concession.
I'm not
because
asking you to make the concession. I'm not fighting with you, because this is not an argument between you and us.
Yeah.
You make the submissions, we make the decisions.
Yeah.
So,
No, that I
Yeah.
accept.
yes, so what is your response to that?
It may have been collegial, so to speak.
Now, I'm
But
asking whether
prudent in
I'm
law
asking you whether
required?
it was prudent, because you are not, the two companies here are not colleagues. Collegiality doesn't come into it. They are undertaking mining operations in competition with each other. You accept that their mining right gives them the right to undertake mining on that entire area of land in Mandachsuk. And you didn't think it was important or prudent to inform them of what you were planning to do, even though their right could extend to the property on which you were undertaking activities. That's just the scope of my question, not a trick question.
We would have had to concede that they were lawful occupiers for purposes of the notification requirement. We did not, because the maize farmers were physically occupying it, and there was no objection in the public process against those activities that obviously, as
Okay.
we've explained, creates that tension.
Okay. So you don't accept that they were lawful occupiers?
No,
And
not for
therefore,
purposes of their course of action.
sure, and therefore you didn't think it was necessary to obtain their consent or inform them. So can I ask you, when you obtained the consent of the 5 directors, these are the 5 directors of the JV, of Modikwa, not so?
Of their JV partners,
Yes,
community leaders on Mandachsuk.
yes. But,
They
but,
form part of the maize farmers,
sure,
obviously
but,
that's in the
but
papers.
you argued earlier on that consent bound Modikwa, because they
We
were,
say in hindsight, yes.
yes.
It does.
So why was that consent necessary?
They
On
were
what
part-
basis?
They were the community leaders of the maize farmers that do occupy, and that's why they were involved
Okay.
in those compensation agreements.
I'm a bit confused. So that consent wasn't consent of Modikwa? You didn't bind Modikwa?
It's their JV partners' consent.
But
How
in
it's
respect of
interpreted.
Modikwa, or in respect of them being farmers? I'm not understanding, because earlier on you indicated that consent was the consent, those 5 directors' consent was the consent of Modikwa, that it bound them as a partner.
If they merely acted on behalf of the maize farmers and the community where they were part of, then obviously they did not act for Modikwa.
But your submission was different. Your submission was that,
If they had,
that as part of a JV, that consent bound Modikwa, not so.
I did argue
That
that.
was your submission.
And
So-
we say if the hat is on as a director, which they are of the JV, it can be interpreted in that way. That there's one consent, and that is by a person who is a community leader but also a director.
Sure.
We
But your,
interpret it in both ways.
but your understanding was that consent bound Modikwa,
Yes, we do.
which means that Modikwa's consent was necessary.
No, we still say it's not necessary. But we say,
So what's the relevance of the submission that the consent bound Modikwa if Modikwa's consent was not necessary?
We say-
Why do you make that submission?
we say it was not necessary But in any event, whilst we obtained the farmers' permission with the occupation agreements, they were involved in those discussions. We also had their consent. And now we interpret it looking back. Hindsight is always 20/20, as you know, Justice Colopin. It may signify Modikwa's tacit consent.
Okay.
Because they are JV partners.
Yeah, it's a bit of a confusing submission, but let me not take it any further. I'll simply take it on the basis that there was an attempt to obtain Modikwa's consent. Just lastly from my side, you said there was no reason for your client to have desisted with any operations because it was the recipient of 2 court orders in its favor, correct?
Yes.
But it was also mindful and consciously aware that in the same month that the SCA had dismissed the appeal, that there was an application brought in this court. So that was in February 2023.
Yes.
So that would have given them a sense that this litigation was certainly not over, that it was now being brought to the highest court. And you say that it took a risk, but it was a risk that it was entitled to take.
Yes.
But you'd accept then that having taken the risk, it must also carry the consequences that if the judgment of this court might go against it, well, what's good for the goose is good for the gander.
No, that's always the
You accept?
risk.
Okay.
Pardon the pun, always the risk of that risk.
And then
But you must remember, Justice Colopin, our argument was if Modikwa, with that application to this court in February 2023, by which time 2021 was long gone and a lot of infrastructure existed also at that time up to December 2024. If they were serious about their application, because now we need to be serious about it, because we need to consider our position, we said their remedy was to approach a court, show prospects of success in a pending application for leave to this court and obtain an interdict. So what's good for the goose is also good for the
but
gander.
I'm not sure if you can hold that against them. I mean, I can't speak for them, but they may have been advised that the prospects of obtaining such an interdict in the face of 2 orders of other courts, and it's likely that another court would have said, well, 2 courts have found against you. We're not going to grant an interdict. You take your chances and proceed. So, yeah, I'm not sure about that proposition. But my last question was on remedy.
May I just make the remark then, what's good for the goose is good for the gander.
Well, I'm a bit confused now who's the goose and who's the gander, so let's leave it at that.
No, no.
Just lastly, what would an arbitrator do in the event that if we find against you, then on the question of what would be an appropriate remedy would go there? Surely we would have to make a determination whether there was a spoliation. If there's a spoliation, then ordinarily the ordinary results would follow. There would have to be a restoration of possession. And the only thing that could arise then is, well, some money has been spent on infrastructure there to remove it will cost so much or whatever, but I'm not sure what, it's almost one of those kind of matters, well, years have passed, activity has taken place, and if it comes to the crunch, that's the order that must be made, and that's it. I mean, we're not dealing with entities of straw either, so, yeah.
I believe the arbitrator, as I understand the MPRDA, concerns himself with monetary compensation.
Yes, but that must mean there's a right to compensation. And it would be hard for this court, if it would find that there was spoliation, that somehow the spoliator has a right to compensation. That would be totally inconsistent.
Now perhaps compensation the other way around. Not us being paid back 150 million odd or whatever, but what we must pay for our continued occupation there.
No, but that can't follow. If we find against you, we can't find that you should occupy. I mean, you can't have your cake. You can't have both your cakes and eat them.
Yeah, that's the problem with the judgment by yourself last week. Perhaps the The
You know what,
self-inflicted harm now
Roux,
becomes
with
prevalent,
respect-
Justice Collington.
With respect, I think you had problems before my judgment last week. My judgment was an intervening fact which can't have any bearing on your difficulties. Okay, let's leave it at that. Thank you.
I was merely thinking of self-inflicted harm as perhaps an answer, because I cannot answer the arbitration point properly.
Okay.
If there's restoration, we ask this court to consider that the landscape has changed and it's not restoration anymore.
Thank you, Mr. Roux.
That's our answer to that.
Mr. Roux, I must say I'm a bit as confused as my colleague next to me, specifically on the approach to consent that you lay out. And perhaps what could help, speaking for myself, if you could give us authority, a judgment in which this approach is set out, that a holder of, or a possessor of a right over a property must have physical presence on each and every corner of that property, and just set and give us an outline of what that case was about and how the court reached that conclusion.
If I may. We have referred to the case of Blenright versus Munisami, a judgment by the SCA that also dealt with incorporeal
Just give me the
rights.
citation again. I know it's, you say it's in your heads, but I haven't had a look at it.
It's 2021,
Yes.
volume 5, page 61, SCA.
Page 61. SA. And just a brief outline of what happened there and what conclusions and what the approach of the court was.
The principles are really important, not the facts, but Munisami and Palani were directors.
It's going to be, I think it will help, certainly myself, to understand
Yes.
how the court then applied the principles to those facts and came to the conclusion that
Yes.
the principle is that there should be physical occupation on all parts of the property.
The starting point is this case where Munisami and Palani were directors of Blenright, and a dispute arose after Palani claimed that Munisami had resigned and the alleged resignation was disputed. Now, Palani caused Blenright's network service provider to terminate the access to the company's email and computer server. Munisami then obtained a High Court spoliation ordering restoration of his access. The legal principle there was that the mandament primarily protects possession of corporeal property, but it may protect quasi-possession of certain incorporeal rights only in a restricted class of cases. Why this is important is because a mining right is an incorporeal right. It's not a physical possession of something. A mining right is issued. It's a piece of paper that has in it certain rights that you may exercise. So there is a need for quasi-possession of that. So in this case, the use of a service may be protected where that use is an incident of possession of corporeal property. For example, an electricity or water supply necessary to use premises in an applicant's possession. What the court then says is, the mandament does not protect the exercise of a pure contractual or personal right unrelated to possession of corporeal property. and it cannot be used to compel specific performance of a disputed contract. So the appeal succeeded and the spoliation application was dismissed. Munasamy did never possess any corporeal right to which his server or email access was incidental. His access arose at most, in that case, from a contractual or corporate right as a director, and the monument could not be used to enforce those disputed rights. So we say the practical relevance of the case as a departing point is the case limits spoliation claims involving corporeal rights. It distinguishes protected incidents of physical possession from contractual or personal entitlements. Here, the physical possession, we have argued, were those exercised, physical possession, by those maize farmers.
So what do you, I don't think that helps me very much, but what is your submission in relation to the judgments, the Bonino judgments that Mr. Brainders referred to? In other words, and the simple example that if I'm renting a property and you purchase it and you have your title deed, can you just come onto the property and set up somewhere in the yard because I'm not there physically?
The example I submit that my learned friend used was one where the one room was empty and can you now occupy? And we'd submit that that is not an apposite example, because when we look at our case, we are working with a mining right that extends 14,000 hectares, and on the common cause fact, where it is exercised are far away from where we
So it
possess
depends
a small
on
property.
the
So
size.
facts are distinguishable in total, and we
So it
cannot
depends on
use
the
that.
size of the property.
Because this is in incorporeal, it depends on all sorts of factors. Obviously the size, where they are exercising their mining right, what have they proved to the court aqua? And that's where our difficulty came about in the first instance. What did they rely on? Because now we are developing towards a case that was never the case in the court aqua.
Yeah, I was just trying to walk through the established principles relating to spoliation. And I'm just wondering if we're going beyond the established proof of peaceful and undisturbed possession and a disturbance of that possession. But I hear you, and I will look further.
Our
on
heads
then, right.
deal with physical possession as a requirement to an extent, but we develop it in our argument. I'm not going to repeat all of that argument. We've
defenses,
dealt with it in
yes.
our heads properly.
Yeah, thank you.
But we say they were not in peaceful possession. The maize farmers was. We did not unlawfully disturb that provision
because
we
they were
had.
not in physical possession.
Yes.
Okay, thank you, Chief Justice.
Yes, and perhaps the second case, the first one was the principles from where we depart, is the Bennett-Pringle case, where the legal principle, I'm not going to discuss all the facts unless I have to, but there's a principle that comes from Bennett-Pringle, and it says possession is a question of degree and must be assessed according to the nature and the use of the property.
Okay.
And perhaps that assists
Which one is that?
It's
case?
Bennett versus Pringle.
Oh,
Versus Adelaide Municipality, sorry. Bennett Pringle versus Adelaide Municipality.
Shall we take a 5-minute adjournment? Just 5 minutes, a comfort break. Afternoon, everyone. Let's get ready. Thank you. Justice Nuku was just about to put a question when we adjourned.
Thank you, Chief Justice. Mr. Rowe, can I direct you to paragraph 53 of the High Court judgment? I think it should be page 637 on the hard copy. The first sentence there tells us that the High Court found that a peaceful and undisturbed possession by Modikwa had been established. And now, when Modikwa went to the SCA, obviously they were happy with that part of the finding because it disposes of one of the elements of spoliation. And my question to you is that, was it open to the SCA, and is it open to this court to revisit that finding in the absence of a cross appeal?
The SCA if I remember correctly, there was a cross appeal to the SCA and it was late. And the Learned Justice Makgoba did not grant condemnation for the late filing of the cross appeal.
Okay, maybe let me take a step
And-
back. Was there a cross appeal or was there not?
There was an attempt to a cross appeal.
So
and
it was not prosecuted.
No, it could not have been prosecuted, but the SCA, in its findings, the Learned Justice Ponnen, as I remember, said that there was no need for a cross appeal because they look at the matter in its full conspectus of evidence before them.
But tell me, as a matter of law, I'm asking you now as a matter of law, whether it was open to the SCA and whether it is open to this court to deal with an issue that has not been brought on appeal.
It is.
Any authority for that proposition? You can ask your junior to look for it. Then the second thing that relates to jurisdiction is this. As I understand, although it's not clearly pleaded, the complaint by Modikwa is this. We're in the High Court, which found in our favor in respect of possession, but then found on a basis that does not exist in law that a statutory authorization can be a defense to spoliation. So that's the issue they took to the SCA. But the SCA did not decide that issue. Instead, looked at a dispute of fact which could not be relevant to the legal point that can a statutory authorization be a defense where, as in here, peaceful and undisturbed possession has been established. And so when I asked Mr. Brandas, he said that's the error of law which was committed by the High Court, and the SA did not attend to that. Would you not consider that to be something that should clothe this court with jurisdiction? If the complaint related to this new defense that had been developed by the High Court, which the SCA did not deal with when invited to do so.
The fact that the SCA did not deal with it does not elevate it to a constitutional jurisdictional point.
Not a
Because the SCA found that there was another dispositive ground to deal with the appeal before them at the time.
And where would that other dispositive ground come from? Because the appellant comes to the court with a particular complaint, and that complaint is not addressed. Would you regard that as a fair hearing? You come to court to complain about A, and then you are told to go away for a reason unrelated to A.
The SCA judgment is what it is. Because what was before them was the full conspectus of the judgment and the evidence presented in the court a quo, and they found a further, or perhaps more telling, deficiency in the case, which they dealt with, and they did not have to deal with any other matter, because it was dispositive. And if they felt it was a constitutional issue, surely the SCA would have raised the issue and dealt with it then.
Thank you, Mr.
May it please you, Justice Nkwe.
Thank you, Chief Justice. Mr. Ru, can I just, the question of law that's been formulated by your opponent is that a statutory authorization is not a defense to a claim of spoliation, correct?
That is our understanding.
What is your answer to that question?
A statutory enactment,
A statutory authorization, not an enactment.
well, is wrong in that instance, because the EA did not originate anywhere else but from NEMA, which is a statutory process that led to the administrative decision following the NEMA process that was followed. So it is, in a sense, a statutory process, statutory resolve, ultimately, granting certain environmental authorizations.
Yes, I think he would accept all of those, and he would still say that that's all irrelevant because of the nature of spoliation, which is purely concerned with the restoration of the status quo antebellum.
But that was never the case. That's the problem that we have and why we argue it's a matter of pleading. Because they did not say we are in possession for X, Y, and Z reasons. Their challenge was, I have a mining right, you don't have any right or consent to do what you are busy doing on the property.
So I'm trying to figure out what your defense is to the claim. Would it be that the case that is being argued is not the pleaded case? Is that correct?
Correct.
Yes. And therefore, the question that they raise for this court's determination does not arise on the pleadings. Is that what you are arguing?
Correct.
Yes.
Because we say lawfulness was established on the challenge posed in the pleadings.
Yes, no, I understand. If the court finds, nevertheless, that the spoliation case is made in the papers separately from the unlawfulness case, do you have any submission to make on the principled argument that a statutory authorization is not a defense to a claim of spoliation, or do you accept what Mr. Brandas says?
It cannot be correct, because then there's no unlawful dispossession. If there's a statutory authorization or enactment, it falls under the category, is there an unlawful deprivation, we say it strikes at lawfulness and it's not unlawful.
So you say on the classic formulation of a spoliation, that element of unlawfulness is defeated by a production of an environmental authorization.
Which result from the statutory process which follows from NEMA. I made a note on that, and I believe I initially dealt with it inter alia under Impala Waters.
So I didn't
Versus
hear
Lawrence.
are you citing a case?
Yeah, that was one of the cases in my original oral argument, the uninterrupted part, that I referred to the Impala Waters case. And
Barlow World. What's the name of the case? Sorry, I just didn't hear.
Impala Waters versus Lawrence.
Do you have a citation?
It is 2008, volume 2, page 495, SCA.
Can I just put the proposition this and get your comment? The element of unlawfulness is heavily relied upon by Justice Mahoka in the High Court. The criticism is that that element does not relate to general unlawfulness in a classic spoliation, but it refers to consent. You see, so it's dispossession without consent. So unlawfulness is a substitute for consent. What is your argument on that score?
Once a party establishes his cause of action different to that which spoliation would normally give you in answering those two questions, and the challenge is accepted and met, then that is the end of it. It strikes at the heart of unlawfulness, perhaps in the bigger sense of the word, other than the classical spoliation.
Yes, no, I understand. I've just, what I'm debating now is assume that we find that on the pleadings, they've put enough on what I call classical spoliation. And there, the authorities say the reference to unlawfulness is merely a substitute for consent. But the way we should understand it is that that simply means consent. So for as long as there is no consent, there is spoliation.
Perhaps that concession one should make.
All right.
It is what it is.
No,
But one should never conflate consent with notice, for instance. Because Section 5AC, that was the complaint in the alternative, did
Yes.
not require consent, but it required notice.
Yes, no, I'm talking about common law
Spoliation.
spoliation.
Yes.
Yes, that
Yes.
the unlawfulness there in the jurisprudence is a substitute for consent.
Yes,
Would you accept that?
I must. That's the law.
Now, that takes me then back to what is in fact your defense to a classic spoliation outside of the pleadings?
Where there is no unlawfulness of activities carried out, where there was public participation ultimately leading to it, of which Modikwa was part of, and if there exists no unlawfulness for that which is carried out there, how can there ever be spoliation in the broader sense?
Yes, and that relies only on the environmental authorization.
And the water use license and the social labor program, the EMPR, all of which are administrative authorizations.
Yes, and none of them depend on the consent of the spoliatee.
The issuing considers objections validly made, which may be an objection, during part of the process in which Modikwa participated, but there were no objections raised. And if there were objections, they were dealt with during the course of that process.
All right. So just to conclude this part of the discussion, then, you would say your defense ultimately relies on the statutory authorizations, If we're against you on that, you have no defense on the common law of spoliation.
In law, no.
Yes, all right. Can I then ask you around the just and equitable remedy? I think your client is in a bit of trouble in the sense that they at some point seem to have acted in good faith to construct all of these roads and dams, etc. What is a box cut? Which is really the major complaint in these pleadings. And it seems common cause that your clients did construct a box cut.
No, not at all.
Is it not common
You
cause?
are wrong, no.
All right.
That was one of the big disputes before Makgoba J and ultimately in the SCA as well. You'd have seen from the papers, Justice Nkwe, that there was an undertaking never to construct a box cut because that would be mining operations. And we cannot conduct mining operations because we don't have a mining right on Mandagsoek.
All right.
Our mining right is on Garatau.
No, I understand, but,
But
the only point is just a factual issue. You are saying on a fair reading of the pleadings, it's not common cause that your client constructed a box cut.
on a fair reading, you are correct. It's not our case. It's never common cause. There is no box cut, albeit that the pleadings try to be elevated now in the answer to the section, the Rule 11 application, to again mention the box cut and provide certain evidence to which we've answered. So that remains a live dispute. We submit there is no box cut on Mandagsoek.
Thank you. I'm sure Mr. Brandes will deal with that. Then finally, on the just and equitable remedy, is there anywhere else in the property? Because as I understand your client's case is this: we've got a mining right for Garatau. We're trying to build a mine there. In order to build this mine, we have to put some of these things somewhere. The rubber that we have to remove, we have to put it somewhere. We've been allowed by the Department of Water Affairs and the Department of Environmental Affairs to put it on Mandagsoek. And that's where it is right now. Now, is there nowhere this can be put in the area that is within the mining right that's given to your client?
It was explained in the papers that Garatau is a mountain, that where we
Yes.
have the mining right. And obviously for tailing dams, etc., you can't do that on a mountain.
But does that mean that the consequence, I'm talking about justice and equitable, the consequence of the restoration is that you have to shut down the shaft in Garatau?
Yes.
Yes.
And we explained what consequences will follow on that.
Yes, no, I understand. I mean, this is more than 1,000 people employed as we speak right now.
I'm not certain of the number, but yes, employees and contractors using all of
Well, I
those
think it was
facilities.
1,500 on the papers.
Maybe.
Yes. That's what I'm asking on just and equitable. I mean, does that mean those people lose their jobs?
Yes.
Yes. Thank you, Chief Justice.
Mr. Root, just one question. I've listened to the debate, and there seems to be a tension between the rights emanating from the MPDRA, that's the mining right, and the rights that emanate from NEMA, the statutory authorizations. Now, just tell me if I'm right or wrong. In dismissing the spoliation, did the High Court not, in effect, hold that the statutory authorizations allow the holder thereof to dispossess the property of the holder of a mining right? So in other words, it elevated those rights over and above the rights that you have in terms of a mining right.
Justice Besson, yes, but also with one qualification, and that is that the activities listed dispossess infrastructure, the top surface, where the listed activities may take place. It certainly did not give rights to go underground at all, because it is not winning minerals there. And their activities there, insofar as it dispossess a certain part of the land surface there, as long as its intention is and would always be to mine next door. That was their consideration, why those rights or those activities were elevated to apply to the surface rights.
Yes, but surely the holder of a mining right has certain surface rights.
Yes,
And the High Court said, well, if you have the authorities, that overrides the rights that the mining rights holder has.
there is that tension, but that was never the case to be argued at that point in time. That was not the cause of action. Because you must remember, Justice Basson, the challenge was we have a mining right and you, Nkwe, has no rights or consent from the landowner whatsoever to be on this land.
Yes, I accept that. It's just when I read the High Court judgment, I wondered why the court did not weigh up the competing rights. Once it went to the merits, or delved into the merits, as it did, then why did it not maybe evaluate the competing rights?
I believe it was because that was not the right of action presented to it in the founding papers. That's the answer to that. I believe there's another answer to that as well. The EAs and all of those administrative decisions was extant administrative decisions issued. He could not have weighed and found it to be of less value because there was no review before him. He could not adjudicate on its efficacy. The wrong process was used, because that only followed in the reply and thereafter to attack the administrative decisions. That was not initially the case.
Thank you, Mr. Roux. Was that all?
After the adjournment, I had to come back to the Bennett Pringle case. And there was one issue that I needed to deal with. I read it initially, but I did not complete that. I just wish to complete that. Possession is a question of degree. And in this context, there are various rights at play. Modikwa mines underground, common cause. Modikwa has surface-related infrastructure to support their underground very far from where Nkwe is. Now the important part is this. Farmers, maize farmers, were the surface right holders at the time when Nkwe moved in there. And they derived benefit from their maize farming. Modikwa could not derive a benefit on the surface because the farmers already occupied that surface and they derived the benefit. That's the problem when it comes to the incorporeal, and that which spoliation was meant for and was developed over the last decade. So if immediate restoration had to take place, according to Yeku versus Kwana, then what would it be? It would be that the farmers had to be backed to their possession, because they were busy with maize farming there. It makes no difference to Modikwa if restoration is ordered, because they remain in possession of their mining right and they continue with their mining.
And why would Modikwa not be in a position to negotiate with those maize farmers to take over the land if it needed to mine there, as did your client?
I respectfully disagree that answers the question. The question is, they may, in the future, if restoration is ordered, go to those maize farmers if they can farm anymore there. because you would have seen what has happened on that land. I don't think it will be as arable farmland as it was, where there are waste dams, etc., 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 not for a very long time at least. But it is theoretically possible that somewhere there can be negotiations with farmers that may be on the ground. But that was not the position factually in 2021.
Anything else, Mr.?
I believe that's our argument.
Thank you. Reply, Mr. Breinders.
Thank you, Chief Justice. Justices, so perhaps the way to go about the reply is to start at the beginning. The application
You
brought...
have 10 minutes.
I know, but I will be brief. The application was a spoliation application. Judge Makgoba found that MPM was in peaceful and undisturbed possession of Maandagshoek. He found that. Nkwe conceded that MPM had and has the mining right over Maandagshoek. Now, so that we're all clear about what that means and what we're talking about, I just want to refer you to, I want to ask you to, not now, but to look at the mining right itself, and it's at page 82, volume 1. And then I would like you to look at the mining area, that's page 89, and that's the diagram that sets out what the mining area is. And it is Maandagshoek, by the way, and that is the registered right of MPM. Then, as regards the, so what's the relationship between the MPM and the farmers or the locals? So MPM says in its affidavit, this is not denied, and I want you to look at page, please, page 10 through to page 11. The consortium is made up of what they call host companies. Those are the locals who form Section 21 companies. The people who signed the consent to occupation of Nkwe were directors of those companies, not directors of the JV. So they're Section 21 companies, they're community companies, they have directors, those directors sign on behalf of those companies, and if you look, please go to volume 3, page 260, page 266, page 267. They say they represent the Mpedima communities. They say they represent the communities when they sign. And nowhere do they say that they sign on behalf of the JV, MPM. Nowhere. And it is not alleged in the application by Nkwe that they signed on behalf of the JV. There's no such evidence. Now let's deal with the question of the defenses. So we've got an application. Oh, just one further thing. Can I just point this out to you? It's at page, so it's volume 1. And I'd like you please to take a look at page 23, paragraph 5.9 through to page 24. That sets out the relationship between the JV and the communities. And it says, this is what it says, not disputed, by the way, that the host communities have been, through their companies, have been shareholders in the JV. And it says, respecting their legal rights, arrangements were made with them, including planning the mine, such that no community was relocated for mining operations and activities incidental thereto. This has enabled the host communities and the applicant to coexist lawfully and peacefully on the applicant's mining area. I mean, no wonder that Judge Makhoba found that we were in peaceful and undisturbed possession. So let's get to the defenses. Justice Nkwe is quite correct. There are limited defenses to the application for spoliation. Statutory authorizations are not enactments. Enactments are statutory acts that enable X to move onto the land of Y without a court order and without its consent. There are such statutory enactments. I mean, they relate mainly to things like security, but this is not one of them. And they've never said that those authorizations are statutory enactments. So now the question is, are statutory authorizations a defense to the mandament, the application of spoliation? Well, our learned friend could give no authority to show that they are. They're not. Judge Makhoba found that they are, and that's where we say the error of law is, but they're not. They don't permit you to occupy against, without, etc., the consent of an occupier or without a court order or without a statutory enactment. They don't. In fact, their purpose is to regulate what you do when you get consent to go onto the land. That's what they regulate. They don't regulate your getting onto the land. It's when you get there and you undertake all these activities, that is what is regulated. That's the nature of environmental and water and waste regulation. That's the, at the application, that was their one defense that they promoted or prosecuted, and that's what Judge Makhoba found for them. The other one they prosecuted was the one that they prosecuted here this morning. In other words, this notion that we were there and not here on our property. Now, frankly, that's turning the law on its head, and I'll tell you why. Because, and I'm going to read, Bennett Pringle, in fact, every single authority that our learned friend referred to is against Nkwe on this point. Every single one. The Lawrence case, which he referred to, doesn't help him because that's a case where the court said that in relation to water, your right to water is protected by the mandament. That's the Lawrence case. In other words, it actually said that even though you didn't need to be a possessor, if you had the right to water flowing from the property, it was good enough. The other case you refer to is a case, I forgot the name now. That's the. That's a case, I'll get the reference now, is a case where the court said, you came here, remember that's the case that involved the email and the email address and...
Denright.
Denright, yes. So that was a case that involved the right to email domain and so on. And there what the court held was, you didn't come on the basis of your possession of a property that gave you access to these things. You came on a contract, and that you can't get you won't get a spoliation application based on a contract. Now I want to read to you this notion. I mean, it's this. So I own a property, and I build. The Chief Justice is my neighbor. To get to my property, I've got to get across the Chief Justice's property. Without a consent or a court order, I open up, I say, well, this property is, I want to be generous to the Chief Justice, 4,000 square meters. She lives on 3,000. There's 1,000 going down here. I'm going to open up a gate on her property, so I'm going to cut a gate in her fence. Then I'm going to build a pathway going all the way to my property, on her property. And my argument is, well, she doesn't use that. I mean, yes, she's in possession, it's her property, she owns it, but she's over there, not here. Now, what do the courts say about that kind of argument that really turns the law on its head? So, here we go. Can I just read to you? I'll give you the authorities. The first is The first is Bennett Pringle, which my learned friend referred to. And I ask you to look at 233 in particular. Bennett Pringle relied on Nienaber versus Stuckey. I've referred you to that. And you should look at 1056. That says Nienaber versus Stuckey at 1049. Look at 1056. And then I want you to look at Morkel's Transport Pty Limited. V. Melrose Foods Pty Limited. 1972 to SA 464W. 1972, Volume 2, SA 464W. And there the court held, counsel for the defendants did not rely on the fact that at no time was every square yard of the disputed ground simultaneously in use by Morkels, or upon the probability that there were short periods during the daytime when all the vehicles were away and there was little or nothing on the ground. For reasons I have given, any such contention would, in my judgment, have been ill-founded. I mean, that's the point that all the justices have been making to my learned friend. His contentions, A, are not supported by any authority, and B, I mean, they turn the law on its head, and B, they're ill-founded. That's what our courts have said. So I urge you to look at those authorities that I've just referred to, and you will see from those authorities that the point he makes is untenable in law. The fact that we started, and if you look, can I just ask you one more? I'll refer you to one more thing. Just look at, in the interlocutory application, there's a pictorial at page 122. There's a sort of pictorial presentation of what Maandagshoek looks like, Garato looks like, and it shows you the mining taking place, and it shows you what area has been fenced off. That's what it shows you. Now, if you look at that 122, 121, 2 years, if you look at that, what they're saying is the area we have fenced, which is that area in green and orange there, is an area where the farmers live and work and farm and so on and so forth. MPM isn't there. They're elsewhere. They're further down the road. They're not there. And therefore, we can walk onto their mining area and set up without their consent or a court order. Well, I've just referred you to authorities, AD downwards, SCA, that say you can't do that. It's not permissible in law. So there is no defense, Justice Nkwe, to your question, to the spoliation application. As for remedy, well, my learned friend readily conceded that his client took the risk, and he must live with the risk. There is the recent judgment, and in that case, this court found that notwithstanding that it was something like R1 billion that had been spent by the exploit by Shell. I think it was R1 billion or slightly more. This court found that despite the fact that R1 billion had been spent, it couldn't get the just and equitable relief that it asked for. And remember, this court will know it very well. I don't need respectfully to remind this court. Just and equitable relief is reserved generally in administrative, that's where you find it, in administrative actions where an administrative act has taken place. And the court sets it aside for invalidity. And then the court asks, well, what do I do with a situation where an innocent third party has, based on that administrative decision, taken measures, gone on with its life, and believed that it could do what it was doing innocently and in good faith, despite the fact that there was something unlawful prohibiting it from doing so. In that case, the court say, well, we come to the assistance of such a party. But who's the innocent third party here? Not Nkwe. So why should the court come to their relief? Unless there's anything else, those are my submissions.
To the end of the proceedings. Thank you all for the submissions. Judgment is reserved. Court adjourns.